Your affair with Kedei? Is she SSC? Yes. Yes. This matter is for judgment. The claimant in this suit by the general form of complaint dated 18th day of April 2023 and filed on the same date against the first, second, and third defendants file a claim against the first, second, and third defendants, while by the motion on notice dated 15th day of August 2023 and filed on the 16th day of August 2023, the first defendant applied to be joined as interested party. On the 30th day of January 2022, the application for joinder was heard and granted by court. Parties were also given 7 days within which to file consequential amendment. On the 5th of June 2024, the claimant amended his complaint and its accompanying processes by order of court. The defendants were also given 14 days to file consequential amendment, if any. By the amended complaint and its accompanying processes, the claimant claim against the defendant jointly and separately as follows. 1. A declaration that the claimant as occupier of House A1, Doctor's Quarters, Kasuk Town, is entitled to be offered or allocated the first option of either purchase or rejection of the offer of purchase to the said house on owner-occupier basis before offering same to the general public or any other person. 2. A declaration that the claimant as an occupier is entitled to purchase and own the property described as house number A1, Doctor's Quarters, Kasuk Town, Municipality, Calabar, having indicated his interest to buy same. 3. A declaration that without first offering the house or giving the opportunity to the claimant to purchase or decline the purchase, the defendant's attempt to sell or purported sale is unlawful and invalid. 4. An order of interlocutory injunction restraining the defendant from interfering with the possession or occupation of house A1, selling, disposing, or dislodging the claimant, or dealing in any other way with house A1 pending the determination of this suit. General damages of 10 million naira for psychological trauma arising from shock of knowledge of the manipulation and incessant threat and intimidation and harassment. 6. 200,000 naira only as cost of this action. Upon being served with the originating process, the first, second, and third defendant filed their statement of defense, while the post defendant who was joined as a defendant files statement of defense and counterclaim. In the counterclaim, the fourth defendant claim as follows: a declaration that the sale of house number A1, Doctor's Quarters, Kasuk Town, Calabar, by the first to third defendant to the fourth defendant is proper and valid. Two, a declaration that the fourth defendant is the owner and entitled to house number A1, Doctor's Quarters, Kasuk Town, Calabar, properly described and delineated in the survey plan number CRR 1179, contained in the deed of assignment between the first defendant and the fourth defendant, dated 25th day of April 2023. Three, a declaration that the action of the claimant retaining possession of the property known as house number A1, Doctor's Quarter, Kasuk Town, Calabar, after service of letter of revocation of his allocation and notice to quit amount trespass on fourth dependent property. Four, an order of interlocutory injunction restraining the claimant, his agent, previous etc. from further act of trespass on the fourth dependent property at house number A1, Doctor's Quarters, Kasuk Town. 5, 10 million naira as for trespass and general damages, appropriate emotional, psychological trauma, etc. 6, 1 million naira for cost of prosecution of this suit. An order mandating the claimant to vacate forthwith the premises of the fourth defendant known as house number A1, Doctor's Quarters, Kasuk Town, Calabar. The case of the claimant. The gist of the claimant grounds that necessitated filing of this suit are that the claimant joined the Cross River State Civil Service on the 13th of August 1996 as a medical doctor. Two, the claimant's employment was confirmed on the 18th day of August 1996 and also promoted to Chief Medical Officer on salary grade level 17 with effect from 1st of January 2010. On the 5th of March 2015, the claimant applied for allocation of a house at Doctor's Quarters, which the first defendant obliged and allocated the house to the claimant. However, the claimant stumbled on a publication in the Nigerian Chronicle of 26th day of October 2022, indicating that the government houses and properties are built to be sold, and house number A1 at Doctor's Quarters is one of the houses to be sold. And to be sold, the claimant indicated his interest by applying to purchase the said house. The claimant, while waiting for letter of allocation, received a quick notice on the 4th of April 2023, which was addressed to all occupants of Plot B2, Doctor's Quarters, Kasuk Town, Calabar Municipality, Calabar. The notice to quiz indicated that the said house has been sold and that further legal action will be taken by government unless the claimant vacates the house within 21 days from the date of the notice. The claimant is still in the civil service in the employment of Cross River State. The house was officially allocated to him following the government policy on monetization. The claimant, being the occupier of A1, ought to be first offered the said of the said house for purchase. However, for purchase on owner-occupier basis. I will skip reading the case of the defendants and the reply that of the fourth defendant and also the reply to it. I also skip reading the submissions of counsel. The counsel for the first, second, and third defendant in the address, final address, which was adopted, formulated twin issues. The argument has been captured in the body of the judgment, while the counsel for the fourth defender, Raymond Manga, also adopted his final written address, wherein twin issues were formulated for determination. The argument on the issues have been captured in the body of the judgment. The claimant formulated through his counsel, Open Oimba, formulated three issues. The argument on the issues were captured in the body of the judgment. There is also a reply on points of law. All the arguments contained in the various written addresses were duly captured in the body of the judgment. So I now go straight to the decision of the court. I have considered the processes filed in this suit, the evidence laid at the trial, as well as the entire case file. I have equally considered the written and oral submissions of counsel for the parties. In determining a case brought before the court, the law requires that the court confine itself to the claim before it. If there is no counterclaim, where there is a counterclaim, the counterclaim being a distinct action must be treated based on the relief claimed by the counterclaimant. In any event, a court is always required to ensure that the parties put forward, the case of the parties as put forward is as encapsulated in the claim and pleading of the parties before the court. This is because a court is entitled only to decide claims that are made before it for adjudication. See the case of Ekpeyo versus Inyong. See also Lainka versus Gegele. See Oluro Tumi versus Ige. See Nwavani versus Golden Guinness Breweries PLC. A court is duty bound to adjudicate between parties on the basis of the claim formulated by them. The court has no business going outside the reliefs of the parties. Thus, a party cannot and should not be allowed to make a case different from his relief sought before the court. See Osuji versus Ekelcha. See Abbas versus Solomon. See Inua versus Inta. See Akim Bolola versus Elison Pisco. It is to be remembered that in civil case, pleadings play an important role in circumscribing and defining the issues in controversy between the parties. See the case of Okpala and Sons versus Nigerian Breweries PLC Limited. In the instant case, the issue upon which this suit will be determined will be defined by the parties themselves, and as far as the sale of the house in dispute is concerned, the law is settled that a claimant's duty is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove them. He may at the end of the day obtain all the relief sought or claim or less. He never gets more than what he has sought for, nor does he obtain reliefs he has not claimed before the court. Court is therefore bound to grant only relief claim. It cannot grant relief not claim. See ATB versus Capital Metal Nigeria Limited. Having regard to the claim and the counterclaim as well as the submissions of counsel for the parties, I am of the view that three issues arose from the claim and the counterclaim for determination. These issues are: one, whether or not the claimant in this suit has disclosed a reasonable course of action against the defendant; two, whether from the facts as disclosed this case, the claimant has established entitlement to any of the relief sought; three, having regard to the execution of the deed of assignment during pendency of this suit, and despite the order of court made on 20th day of April 2023 for maintaining status quo, the post-defendant is entitled to the relief sought in the counterclaim. I turn to issue 1, whether or not the claimant in this suit has disclosed reasonable course of action against the defendant. The counsel for the post-defendant submitted while relying on the case of Bello versus Attorney General of Oyo State that the claimant's complaint, when read together with the statement of fact, does not disclose reasonable course of action. Counsel further submitted that, as indicated in the amended statement of fact, the wrongful act of the first defendant is his choice of offering for sale to the public his own properties on the first come first served basis, which the claimant could not qualify. By this, it is submitted if proved the claimant may not be entitled to damages for breach of contract, violation of any statutes, or any civil wrong, according to counsel, applying the two elements in the definition of course of action vis-a-vis facts of the instant case. The claimant does not disclose a reasonable course of action. For the counsel for the claimant, there exists a course of action as the tenancy of the claimant subsisted as at the time the property was advertised for sale, and by virtue of the application to purchase same, he was entitled to right of first refusal. The claimant, by his statement of fact, has shown facts which depict a wrong occasioned by the defendants, denying him the right of first refusal, which is capable of granting him the relief sought. A course of action has been defined as the entire set of facts that establishes or gives rise to a right to sue. It comprises two primary elements, namely the defendant's wrong acts that give the plaintiff a course of action, then the consequent damage suffered by the claimant. For a course of action to be valid, the claimant The law recognizes a course of action once the factual situation on which the claimant relies support an enforceable right or claim against the defendant. See Shell Petroleum BP Development Company Limited and others versus Onasanya. On the other hand, a reasonable course of action means a course of action that has some chances of success when only the allegation on the pleadings are considered and when no defense is raised. See the case of Thomas versus Olufosoye. This means the statement of claim must set out the legal rights of the claimant and obligation of the defendant, i.e., facts detailing facts constituting an infraction of the claimant's right or failure of the defendant to fulfill its obligation in a way that if no proper defense exists, the claimant will succeed in the relief or remedy sought. In determining course of action or reasonable course of action, the court is enjoined to restrict its consideration to the pleadings of the part of the claimant. In the instant case, claimant has above that he is an employee of the defendant. In the course of his employment with the defendant, he was allocated house number A1, Doctor's Quarters, Kasuk Town, Calabar, that as a sitting tenant or person in occupation of the house in dispute, he is entitled to right of first refusal before the house can be offered to the general public for sale. I have no doubt in my mind that the pleadings of the claimant has already established a reasonable course of action respecting the sale of house in which he was an allottee or an occupant of the said house. Therefore, the objection of counsel for the first defendant on non-disclosure of reasonable course of action is misconceived. Same is hereby dismissed for lacking in merit. I now go to issue 2, whether from the fact disclosed, in this case, the claimant has established entitlement to any of the relief sought. The counsel for the claimant has submitted that the claimant has unbalance of probability or preponderance of evidence prove entitlement to the relief sought before the court. Counsel made reference to definition of tenant and argued that the claimant is a tenant as the qualification of becoming a tenant is lawful occupation. Whenever an initial entry is lawful, such occupier becomes a tenant to the landlord. The claimant in this case being occupier of his employer's property in service occupy or serve is in occupies service or service tenancy. The claimant falls within this category of tenancy and his tenancy has not been revoked at the time as at no time that his tenancy was lawfully revoked. The defendants on their part insisted that claimant has not proved entitlement to any of the relief being sought as he failed to pay rent and is no longer in occupation of the said property. He has also rented the house to a third party. Consequently, the allocation was revoked and quick notice given to him to vacate the house. Counsel for the claimant has argued in response that the contention of the defendant that the claimant was no longer a lawful tenant because he failed to pay rent cannot be sustained as the claimant was not in occupation based on payment of rent. And his failure to pay rent cannot be blamed on him. He also stated that he has not been served with any notice of revocation or notice to quit the said property. Counsel asked the court to reject the submissions of the defendant. Counsel further argued that the evidence in support are not credible, believable, and should be discountenanced. As the first defendant under cross-examination has stated that all her knowledge of the claimant tenancy was derived from third party. This means evidence of first defendant is hearsay, which means it's not admissible. Counsel refers to Exhibit MJ04 and argued that exhibit contained information within the knowledge of first, second, and third defendant, but assigned by the permanent secretary and not the claimant. DW1 contradicted Exhibit MOJ4 in that the form is not the type written and not handwritten. The claimant also failed to pay rent for the entire period of his tenancy. The response of the claimant is that the house was dilapidated when it was allocated to him. He was not to pay rent. Rather, he was to fix and repair the property to be in habitable condition. To show dilapidation, Exhibit 31112A to B was tendered in evidence. On revocation, claimant denied being served with Exhibit MOJ3, the letter of revocation, on the allegation that the claimant rented the property to third party. The claimant stated this is an allegation that amounts to serious misconduct, which requires disciplinary action to be taken, but no disciplinary action was taken against the claimant by the defendant. Counsel asked the court to consider Exhibit MOJ3 as document made in contemplation of this suit as per Section 83, subsection 3 of the Evidence Act. On notice to quit dated 4th day of April 2023, Exhibit C6, which was dropped in the claimant's property, it did not qualify as quit notice. No name of tenant was stated. The address on correct. The tenure of tenancy was not specified, whether an annual, monthly, or tenant at will. Counsel urged the court to discountenance the purported notice to quit and in totality hold that the tenancy of the claimant subsists at the time this issue arose. Counsel also urged the court to hold that the defendant have failed to prove that tenancy of the claimant has been revoked or determined. Counsel submitted that in Exhibit MOJ1 at second page, the first 3 lines of the last paragraph clearly show that there is an existing policy which gives civil servants first priority in the sale of government property. This, according to counsel, aligned with the claimant's position that he was orally informed he was formally informed of the preference that will be shown to his application in meeting held with the official of the Ministry of Lands, and that the principle of first come first served applied to properties not being occupied by civil servants. Resolution of the issue. The resolution of this issue revolves around the relief sought by the claimant, the first, second, and third defendant being the relief sought by the claimant being declaratory, the first, second, and third relief being sought by the defendant being declaratory as the main relief of the claimant. The other 3 reliefs are incidental and ancillary, dependent on the grant of the first 3 reliefs. In an action where declarations are being sought, the claimant has a heavy duty of proof, a heavy burden of proof, as no declaration can be granted until the court is fully satisfied of the claimant's entitlement to the declaration being sought. Therefore, the claimant is required to satisfy the court by the evidence adduced by him that he is entitled to grant of declaration being sought. The law places a legal and evidential burden on the claimant to establish his claim by preponderance of evidence or on balance of probabilities. And the other 3 reliefs sought are invariably predicted on the success of the main 3 reliefs that are declaratory in nature. Put simply, the claimant must establish that he is entitled to a declaratory relief sought before there can be any consideration of the defense put forward by the defendant. I must say that it really needs no further emphasis that the burden of proof on claimant in establishing declaratory relief to the satisfaction of the court is quite heavy in the sense that such declaratory relief are not granted as a matter of on admission by the defendant, where the claimant fails to establish his entitlement to declaration by his own evidence, he cannot be granted such declaration. See the case of Adamu versus Nigerian Air Force. See also Mary Odili JSC, as he then was now retired, where it says, "It is my humble view that the burden of proof on appellant in establishing declaratory reliefs are not granted even on admission by the defendant respondent herein. In this instant appeal, the appellant failed to discharge the burden on him in the lower court, and it is not difficult to so hold. It needs to be brought to the fore that declaratory reliefs are not granted based on lack of credible evidence by the defense, but on the convincing, satisfactory, and credible evidence by the claimant. Assuming that the respondent's evidence were not satisfactory enough, that is not a pointer that the declaratory relief should be granted. See further the decision in the Aquino and others versus Interim and others. See also Diora and others versus Okapo and others. See also Mohammed versus Wamako and others. It is apparent from the decision of the Apex Court just quoted above that the submissions of counsel for the claimant on the evidence of the defendant, that on the submission that the evidence of the defendants is not believable and they are not cogent and compelling evidence, but to prove their defense is of no moment at this time when there are declaratory relief in question, until the claimant is able to, by assistance of his case, able to prove his declaratory relief, Otherwise, he will not be entitled to any judgment. See the case of Akande versus Adisa and another. It is also well settled law that in claim for declaratory relief, the claimant is strictly required to plead and prove his claim on the evidence adduced by him without relying on the evidence called by the defendant, even where the evidence later support his claim. This statement of the law has long been laid down by the apex court and followed by courts in their decisions. In the case of Bello versus Eweka, the Supreme Court of Nigeria, Pa Obaseki JSC of blessed memory, captured the legal position as follows. It is true as was contended before us by the appellant counsel that the rules of court and evidence relieve a party of the need to prove what is admitted. But where the court is called upon to make a declaration of right, it is incumbent on the party claiming to be entitled to declaration to satisfy the court by evidence, not by admission in the pleadings of the defendant that he is entitled to that declaration. The necessity for this arises from the fact that the court has a discretion to grant or refuse declaration, and the success of a claimant in such an action depends entirely on the strength of his own case and not on the weakness of the defense. See the case of Kodelie versus Mbanefo Odu. See also Akinola versus Olowo. From the above stated position of the law, the legal burden on the claimant hearing to adduce cogent and credible evidence to prove the case set up in his pleading is therefore very heavy. The law remains that the general evidence of burden of proof in civil cases on the person who affirmed the affirmative under section 135, 137 of the Evidence Act. In this case, if the claimant who affirmed the affirmative and who wants the court to give judgment in his favor, therefore he has the burden of proving that he is entitled to the relief sought by him in this case. By the above provisions, by the provisions of the Evidence Act, it is the requirement of the law that he who asserts a fact must prove that fact. Hence, in all civil matters, generally proof rests squarely on the person who approaches the court seeking that his legal right, which he claims from another, should be restored to him. Also, the burden is very heavy. It's very heavy on the claimant when there are declaratory claims. See Ade Jube versus Deborah. See also Dumes Nigeria Limited versus Nwokoba. See also Ada versus Ubandawaki. See also Emenike versus PDP. See Akimbade versus and another versus Babatunde and others. For the claimant to successfully prove his claim, he has the burden to prove a valid and subsisting entitlement to be given the right of test refusal or test refusal as claimed by him. This can only be done by leading cogent, credible evidence showing that he is validly entitled to right of test refusal by virtue of allocation of House A Doctor's Quarters, Kasuk Town, Calabar. I shall stress here that in labor law, it is the instrument, a law or circular or collective agreement that confers entitlement to an employee, whether of government or private organization. See Mohammed versus Dungus and ENL Consortium Limited, where this court held that now the rule is that it is the claimant who claims that must prove, and in labor relations, an employee can only claim if he shows entitlement. An entitlement is shown by reference to the law that gives it the collective agreement from which the entitlement was agreed on between the contracting parties, or the conditions of service governing the relationships of the employee and his employer. And in and by Gabriel Atibi versus, and by the case of Gabriel Atibi versus Nigeria Limited. The Supreme Court has made it clear that a claim is circumscribed, and the duty of claimant therefore is to plead only such facts as are materials and necessary to sustain the reliefs and adduce evidence to prove them. Now, a look at all the relief being sought by the claimant will show that they are hinged on the monetization policy of federal government adopted by Cross River State government as pointed out earlier. The first three reliefs are the main reliefs which are claims for declarations, and the remaining three reliefs are ancillary to the main relief. The case of the claimant is that he has acquired vested right in respect of house, subject matter of this suit. He has a courtesy of monetization policy of federal government, which he stated that the state government has adopted. The claimant placed heavy reliance on publication of 26th day of October 2022 as contained in Nigerian Chronicle publication, which was tendered and admitted in evidence as Exhibit DC 3. He also relied on Exhibit MOJ1 tendered by the defendant as documents supporting the claim of being given right of first refusal. I have thoroughly examined Exhibit C1, C2, C3, C4, C5, C6, MOJ1, MOJ2, relied by the claimant to prove his claim of entitlement to first refusal. There is nothing in this exhibit that shows or indicated that the claimant has right to first refusal or to be given option of purchasing the property in question, as there was no such policy before the court. The evidence that would have cleared and indicated whether the claimant has such right of first refusal was not brought before the court, i.e., the federal government monetization policy, which claimant stated that in his pleading was adopted by the first defendant for sale of houses occupied by employees. The failure of claimant to produce the adopted monetization policy is fatal to his case, as court can only rely on evidence before it, produced or adduced before it, and not what was hidden from the views of the court. This means the claimant has failed to establish the right to first refusal. I am strengthened is my view by the fact that mere allocation of house A1, doctor's quarters, Kasuk Town, Calabar is not enough to vest in the claimant right to first refusal. The Court of Appeal was emphatic that the rights given to an occupier of government property to first refusal to buy it does not vest in him or her any right or interest in the property itself. His or her right of first refusal lapses or ceases to exist once the property is sold. The remedies that may be available to the occupant of such house who was not accorded right of first refusal to purchase or refuse to purchase the house is damages against the first respondent for wrongful deprivation of the right of first refusal. The first respondent breach of the guideline in Exhibit R in deciding whom to sell the property to in Exhibit R cannot affect the concluded contract of sale of such house between the first respondent and another house. The second respondent, who is not a party to the sale, contract, cannot sue on the contract or contest its validity for any reason. It can be adduced. It can be deduced from the above quoted decision of the Court of Appeal that even if the claimant has right of first refusal, which is denied in this case, the denial cannot vitiate the step taken by the appreciate the step taken to allocate the said property to another person, while employee occupying government quarters may have the opportunity to purchase the property. This is contingent upon government policy. In the case of Unwana versus FCDA, the Supreme Court has addressed the status of employee occupying government quarters. The court decision is crucial to the effect that employee occupying government quarters is typically considered a licensee rather than as a tenant. This clarification arises because the occupation of quarters is incidental to the employment and not based on the landlord-tenant relationship basis. The employee does not have exclusive possession of the property, which is a hallmark of tenancy. Instead, the occupation is mere akin to a license, which is personal privilege granted to the employee to use the property as long as he remains in service of his employer. This does not deprive the government or his employer the right to sell or lease its own properties. The instance of the claimant the insistence of the claimant of his right to be given first refusal because he is in occupation of property is a weak standpoint. The reason being that despite insisting in his pleading that he is in occupation of the property, he has admitted not to pay rent, which is well known to every government employee, that upon being provided with accommodation, the employee forfeits his rent or housing allowance to government. In order to justify non-payment of rent to the government, the claimant argued that it is the responsibility of the government to deduct the rent allowance, which it failed to do. Even if officials of government have failed in their duty, the claimant, who is well aware the allocation of government quotas translate to forfeiting rent housing allowance, has a duty to ensure that the said rent housing allowance being paid to him by government is deducted. The failure of the defendant to ensure deduction is made from shows the dishonest intent regarding his dishonest intent of the claimant in regard to not paying the rent to the government. In another brief, the claimant stated that the house allocated is dilapidated, and the understanding was that he should use his finances to renovate it in lieu of rent. This claim is an afterthought to justify clinging to any excuse of not paying the rent, as there is no proof of such agreement that existed between him and the first defendant, his employer. In Exhibit C6, the letter of allocation, it is clearly stated in paragraph 3 that the claimant should call on Estate Department, Ministry of Land and Housing, Calabar, to collect a copy of tenancy agreement, which contains the conditions under which tenancy was granted to him. However, the claimant has failed and neglected to tender the said agreement, which he was asked to collect, which will govern his allocation of the house. The failure and refusal of the claimant to collect the said agreement stated in Exhibit C6 clearly shows that the claimant cannot claim right of first refusal, as the agreement that may show or grant him such a right was not collected by him. This means there was no such right in either his agreement with the defendant or in any policy that exists, as that policy has not also been adduced or produced before the court for inspection of the court. From the evidence before me, more particularly a combined reading of Exhibit MOJ1 and MOJ2 will reveal that the sale of lease of dilapidated houses, the sale or lease of house number A1 doctor's quarters, Kasuk's town was not restricted to, to, to only those in occupation of the houses. The members of the general public, occupants, and other public servants are invested with the right to participate in the sale or lease exercise introduced by government as advertised or announced in Exhibit MOJ to the Nigerian Chronicle newspaper of 26th day of October 2022. And the said exercise is on first come first served basis and not on right of first refusal by occupant. From Exhibit C4 and DC4 clearly shows that fourth defendant test applied on 28th day of October 22 for sale or lease of the house in question, while the claimant applied on the 8th of November 2022. That is 11 days after the fourth defendant has submitted her application. This means, based on the policy as contained in Exhibit MJ2, the first defendant was first in time and claimant second in time. This has also not been disputed by the claimant. In view of all what I have been saying above, the claimant has willfully failed to establish that he has failed to establish his right of first refusal in respect of the sale lease of exercise conducted in line with Exhibit MOJ2, the newspaper publication announcing the said exercise. I now move to issue 3, which is having regard to the execution of deed of assignment during the pendency of this suit and despite the order of court made on 20th day of April 2023 for maintaining status quo. The first defendant is entitled to relief sought in the counterclaim. The first defendant has included counterclaim in her amended statement of defense, wherein she sought for order of court affirming the sale of house A1 doctor's quarters to her, as the said house was sold to her and she had paid the reserved price of the house shown by Exhibit DC6, receipt issued to her by as acknowledgement of payment of the reserved price. The claimant on 4th of April 2024 filed his reply to the first defendant statement of defense, wherein he averred that the first defendant is at best a meddlesome interloper whose purported history of payment and documentation took place in contravention of order of this honorable court, thus entitling her to counterclaim to the counterclaim to be dismissed with court. The chronology of the purported purchase of the property by first defendant is riddled with hints of impropriety and breach of government policy. It is right that a counterclaim is for all intent and purposes a separate, independent, and distinct action. It is in the same position as a claim, being itself a cross action, and subject to the same rules of court as regard pleadings and evidence. Thus, the defendant cannot merely rely on his pleading in counterclaim alone or evidence adduced in the main suit. The onus lies on him to prove his counterclaim on the preponderance of credible evidence. He has a duty to satisfy the court that he was indeed entitled to the relief sought in the counterclaim by adducing positive evidence in that regard. This is absolutely so because it is also a well-settled principle of law that he who asserts must prove his assertion by credible and unequivocal evidence. Otherwise, his claim fails. Thus, he must rely on the strength of his case and not on the weakness of the defense. See the case of Onya versus Godwin. See also OOMF Limited versus NACB Limited. See also Garba versus Food and Dulov versus Kolo. From the record of proceedings, the claimant took out a general form of complaint against the defendant on the 18th day of April 2023 The claimant filed along with his originating process commencing this suit a motion ex parte and a motion on notice. In the motion ex parte, the claimant sought for an order restraining the defendants, whether by themselves or through their agents, servant, workmen, or others, howsoever called from evicting, selling, dealing, or interfering with the possession of the house, A1 subject matter of this suit, in a manner inconsistent with the interest of the claimant pending hearing and determination of the motion on notice for interlocutory injunction. On the 20th day of April 2023, the counsel for the claimant moved the motion ex parte. In its ruling, the court ordered parties to maintain status quo and not to do anything that would jeopardize the hearing of the motion on notice for interlocutory injunction. On the 28th day of April 2023, DB Aripo Esquire counsel for the claimant moved the claimant's motion on notice for interlocutory injunction from the affidavit of service in the case filed on behalf of filed by the bailiff of this court, the general form of complaint and its accompanying processes, motion on notice filed on 18th day of April 2023, and a roll order of this court made on 20th day of April 2023 were all served on the first, second, and third defendant. It is also a record that first defendant by letter dated 20th day of April 2023, DC7A, applied for clearance and receipt of all title documents in respect of House A, Dr. Scotland's Kasuk Town, Calabar municipality. This is because, according to the first defendant, she had completed full payment for the said property to Mrs. Garage, Henshaw, and Co. as far as the receipt issued to her Exhibit D is concerned. The deed of assignment in favor of the first defendant was executed on the 24th day of April 2023. See Exhibit DC7B. The survey plan prepared on 27th day of April 2023 was tendered in evidence as Exhibit DC7C by the first defendant. It is clear from the evidence before the court that the first, second, and third defendant became aware of the existence of this suit as well as the roll order of this court made on 20th day of April 2023, ordering the parties in this suit to maintain status quo. On the 25th day of April 2023, the day Exhibit D7A was executed by the parties. The originating process and a roll order of the court were served on the defendant on 25th day of April 2023. This means that though the deed of assignment was stated to have been executed on 25th day of April, the first and second defendant, despite being aware of the order of the court made on 20th day of April 2023, ordering them to maintain status quo and not to do anything to jeopardize the hearing of the motion for interlocutory injunction, decided to flagrantly disobey the order and proceeded on 26th day of April 2023 to register the said deed of assignment. They also proceeded, despite the order of court, to have the survey plan Exhibit C7C to be signed on 27th day of April 2023. The three defendants did not stop at that. They also assessed stamp duty to be paid on the 28th day of April 2023. However, the assessed stamp duty of 150,000 was said to have been paid on 26th day of April 2023. That is a day before the day of the signing of the said the date of the assessment of the said stamp duty. Then one is left to ask the question, how did the first defendant know the amount to be paid when as at the time of the payment there was no such assessment made by the defendant? This is a question that has not been answered by any of the parties. It is clear from the above revelation, from the record of proceedings, that the first defendant was not a party to this suit as at 24th 26th and 27th and 28th of April 2023, when the process for execution and issuance of the deed of assignment was conducted by the defendant in this case. The first defendant was not yet a party in this suit. Therefore, it can be said that the first defendant was not aware of the said order as at 25th, 26th, and 26th, 27th, and 28th of this. But the first, second, and third defendants were fully well aware of the order, but decided to deliberately and flagrantly disobey the clear order of the court made on 20th day of April 2023, which was served on them on the 25th day of April 2023. They tried to be clever by half as they hurriedly, upon becoming aware of the order of the court, vigorously pursued the execution of the said deed of assignment in favor of the first defendant. The first, second, and third defendants were bound by the order of this court made on 20th day of April and did not have a choice of whether to obey it or not to obey. It was binding without exception. It is the law that where proceedings are pending before a court wherein injunctive relief are sought, the party against whom those injunctive reliefs are sought in order is under obligation to refrain from doing that which is sought to be restrained, even when no temporary order of injunction may have been granted. How much more when an actual order of injunction is made, as in this case, see Ezebo versus FATB, see also Abiodun versus Chief Judge of Kwara State, see also Ade Parati versus Governor of Ondo State, see Governor of Ondo State. Consequently, it is the law that no one is allowed to interfere in the judicial process or take steps during the pendency of a suit before a court of law, or to tend to whittle down and impugn the powers of the court before which the processes subsist, or which will in any way prostrate the cause of justice. The court frowns at any attempt by a party to the proceeding to overreach his adversary and create an impression that he will undermine the authority or order or integrity of the court. Obeying court order is both a legal and moral obligation on parties. A party cannot therefore choose which court or order to obey and which to disregard, because he does not have the luxury of such choice. Thus, in disregard of a valid and substitute court order is at the peril of the party disobeying, which is what transpired in the instant case. See the case of Abdi versus Princewell, see Gorogo versus Mohammed. Therefore, the order made by this court remained extant and binding on the parties without any other choice. The order having not been discharged by the court, the order is meant to be obeyed. The general and acceptable presumption of law is that a judgment or order of court of competent jurisdiction is right and remain valid until set aside by an appellate court. Since the order of this court made on 20th day of April was not set aside same during the course of the trial, and there was no any appellate order setting it aside, the order remained extant for the duration, and binding of the parties. See the case of Dukonga versus Abifan and Co. Limited. See also Abi versus Prince Will Supra. When a court finds itself in this situation, the remedy is clear. It will not only frown against it. The court must, in addition, take a positive and mandatory act in order to instill judicial discipline on the erring party in order to maintain, restore, and preserve the dignity and respect of the court. This includes the undoing of what has been done by the erring party. See Ezebu versus FATB. See also Daniel versus Ferguson. Since the first and third defendant took it upon themselves to flagrantly disregard the order of the court, of this court, under their capricious belief of exercising their power of transfer, they must face the dire consequences of their actions. No court was of its office would condone such a conduct that denigrate the authority, dignity, or respect of the court. By continuing with the process of transfer of ownership of House A1, Doctors Quarters, Kasuk Town, Calabar, during the pendency of this proceeding, after the claimant has filed this suit and obtained an interim order, was nothing but an attempt to anticipate the outcome of the case and ought to poise a fait accompli on the court. The game plan of the first, second, and third defendant was exposed by tampering, which dates by tampering with dates. Some of the activities carried out of perfect the assignment, the assignment in favor of the third on favor of the fourth defendant. For instance, the assessment of stamp duty was said to have been done on 28th day of April 2023, while the payment for the said stamp duty was said to have been done on the 26th day of April 2022. This is incredible. Can this be true? See the back of the deed of assignment for this incredible act on 26th day of April 2023. Can such be possible for a stamp duty to be paid before the assessment is made known to the party paying? I note from Exhibit C attached to the affidavit in support of the motion for joinder filed on the 16th day of April 2023, which this court is entitled to look at as being part of the record of this court. There is attached to the deed of assignment a letter dated 26th day of April 2023 addressed to the post defendant by the Surveyor General, forwarding a copy of survey plan to the post defendant for her record. The said survey plan was tendered in evidence by the post defendant as Exhibit DC7C. The question begging for answer respecting the survey plan is that can a document executed on a particular day be transmitted to another person before the execution? I do not think so, as it will not be possible for the Surveyor General to forward to the post defendant what he has not signed before the said survey plan was said to have been signed. This question arose due to the fact that the survey plan was signed by the Surveyor General on the 27th day of April 2023, as shown by the survey plan tendered by the post defendant. This means that there is a game plan played regarding the execution and deed of assignment in favor of the post defendant. From all I have been saying above, the defendants refused to accord respect to the order. The first, second, and third defendant refused to accord respect to the order made on 20th day of April 2025 by deciding to proceed to conclude signing of the deed of assignment and registering same in clear violation of the order of court. In the circumstances, the first, second, and third defendant failure to accord this court its deserved respect by obeying its clear and unambiguous order. In the circumstances of this case, there is no justification for this court to grant the relief sought by the post defendant counter-claimant as contained in the counter-claim. It is not. This means that the post defendant is not entitled to grant of any of the reliefs, more particularly when the main reliefs are declaratory in nature, which has to be to the satisfaction of the court. Therefore, counter-claim fail, same is hereby dismissed. By, as pointed out earlier in this judgment, disobedience of court order is serious breach that erode the confidence and integrity of the court system. Parties submitting jurisdiction to the court as pointed out earlier in this judgment, disobedience of court order is a serious breach that erodes confidence and integrity of the court system. Parties, by submitting to the jurisdiction of the court, are expected to ensure that nothing is done to affect the pending matter before the court until final determination, even where there is no order directing the parties to maintain status quo. They have such more legal and moral obligation to accord the court respect, to accord the process of the court respect. The claimant has abided in his pleading that the defendant on the 27th day of April 2023, despite the pendency of this case, scrupulously went into the property in question and planted beacons, all in attempt to deprive him of the opportunity to own the house in this case. The claimant has averred that he was traumatized he was traumatized together with members of his household as they were under threat of eviction by the agent of the defendant, who keeps threatening to eject them. Though this court has found that the claimant is not entitled to right of first refusal, he has nevertheless shown that the action of the first and second defendant, refusing to obey order of the court, has put him in discomfort. In the circumstances, the claimant is entitled to some compensation for the heinous act of the defendant, of the first, second, and third defendant, in refusing to pay court's order, asking them to maintain status quo and not to do anything that will jeopardize the determination of the motion for interlocutory injunction. In view of my finding that the claimant is entitled to damages in the circumstances of this court, and by virtue of the provision of sections 14 and 19 of the National Industrial Code Act 2006, I hereby a consequential order awarding the sum of 3 million naira damages in favor of the claimant against the first, second, and third defendants for their acts in disregarding the order of this court. The post defendant counter claimant will, in the circumstances, not be held liable in disobedience of the court order, because as at the time the order was made, the post defendant was not a party before the court, and there was no any evidence to show that as at that date the post defendant was aware of the order, of the existence of the order of the court, and as at that time the order was not made against the post defendant. Therefore, the post defendant cannot be held liable for the disobedience of the order made on 20th day of April 2023. From all I have been saying above, the claimant as well as the counter claimant in this case have woefully failed to prove their respective cases and the claimant is not entitled to any right of first refusal, while the counter claimant is not entitled to the discretion of this court to be granted all the relief sought by her because of the conduct of the first and second defendant before the court, which shows a clear disrespect which clearly shows disrespect by the first, second, and third defendant to the integrity of the court, and that must be condemned. And the court must ensure that it punishes that act of disobedience. In the circumstances, I order the parties to bear their respective costs. Judgment is entered accordingly. Yes. Yes, Mr. Call the next question. Yes. I did not nullify your this thing now. I did not say your allocation is null and void. The court did not nullify your allocation or the self view. It's only that you say you were not punished with anything. You and the damages imposed was against first, second is clear. First, second, and third defendant. Call the next case. You say you are not satisfied, go now appeal, is it?
It's online, so the lawyer is online.
Okay.
Mr. Oscar Obas and First Bank of Nigeria PLC. My lord, the claimant in court, defendant absent.
Appearance. Appearance.
Please, my lord.
Yes.
I am.
Yes, the claimant is online. The counsel for the claimant is online. Yes, counsel.
Yeah, may I please, my lord?
Yes.
My name is Daniel Key.
Yes.
I'm here for the claimant.
Yes.
My lord, the matter adjourned to today for adoption of final written addresses of the past. And my lord, with your leave, we are ready to proceed.
Have you filed your addresses? Have you filed your addresses?
Yes, my lord. My lord, we filed on the 24th of June, 2025. And then the claimants filed subsequently.
Yes. Yes, counsel for the defendant.
Yes, please.
Yes.
Filed first on the 2nd of July. I will be seeking your leave to withdraw that of 2nd July. We will be relying on the one filed on the 9th July.
Have you served it on the claimant?
Yes, ma'am.
You say you filed it or when? Hey, why? Come. Why is the
Inside the file because it was carrying a wrong suit number 16, so we didn't bother putting it in the file.
you put it now? How can you know? Why is it?
It's in the registry.
Collect it. Yes, Mr. Abraham, you said
Applying to withdraw the defendant's final address.
yes, Mr. Daniel. Unmute yourself, counsel.
Yes, my
Are
lord.
you opposed to the application?
My lord, we are not opposing the application.
The defendant's final address file on 2nd day of July 2025 is hereby struck out as same having been withdrawn without objection.
As court prisoners.
Have you served it on the other party? When? When did you file the application? Counsel, have you been served with the motion?
Yes, my lord. My lord, we were served yesterday. I will not be opposing the application, my lord.
Okay.
Yes, my lord.
The motion notice dated 2nd day of July 2025 and filed on the 9th of July 2025 is hereby granted as prayed. Yes.
As a court prisoner.
Yes.
I don't read it. And live of all the part of no argument from bad hearing. According my Lord, to dismiss
Yes.
Contravene in the course of contravene the policies of the handbook. Defendant was rightfully queried. And that was the law of the other party. The man was heard by a panel. How we want Lord will emphasize what that the master servant relationship and right to the
Yes. Yes, Mr. Daniel.
Yes, my lord. My lord, on the part of the claim,
Yes.
we filed our written address on the 20th day of June 2025.
You say you did what?
We filed a written address on the 24th day of June 2025.
Yes.
My lord, we adopt the said written address as our written submission in this case and urge, my lord, to grant all the reliefs sought by the claimant.
Yes.
My Lord, especially because
Yes.
the defendant, by not responding to arguments canvassed in a written address,
You said because the defendant did not do what?
did not respond to arguments advanced in a written address.
Failure to adduce to canvass address, is that material to warrant?
Well, my Lord, it is that he has considered to those arguments. Well, Lord, what he has before my Lord is a one-page argument in response to our arguments. Lord.
Yes.
My Lord, we pray, my Lord, most respectfully. We thank you, my Lord.
Yeah, let me see again.
Thank you, sir.
Council, the time now, we are going on vacation in July, in this month, toward the end of this month, and we will resume until end of September. So taking this address today means that if we are to abide by the 90 days, the judgment has to be delivered during vacation. So the date I will give you will be within vacation, so the judgment will be delivered virtually.
As the court pleases.
This case is adjourned to 18th of August 2025 for judgment. The judgment is delivered.
As the court pleases. As the court pleases.
And one, Cross-River State Government. Two, the Attorney General and Commissioner for Justice, Cross-River State. Three, the Head of Service, Cross-River State. Four, Cross-River State Civil Service Commission. Five, the Chairman, Cross-River State Civil Service Commission. My Lord, parties are absent.
Appearance.